Hello, it's Phillip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at this book from Oxford University Press, and this is a long review, not a short clip. It's called Legal Professional Privilege for Corporations, and it's got a subtitle, A Guide to 4 Major Common Law Jurisdictions. It's been written by Andrew Higgins, and this is the book here. Let's see what it looks like from the inside. There's the front cover itself. You can see a lot of table of cases, extremely helpful. The foreword is always worth reading. You've got a contents section there as well, it gives you an idea of what's in it, and of course what you do have is paragraph numbering at the sides and very detailed footnotes, which are extremely helpful, of course, for trying to find things quite quickly. The index is very good, up to the standards that we would expect from OUP, very detailed, and as I say, there's a lot of very substantial information in this publication. It's not a heavy book, it runs to about just under 300 pages in total. I'll put it up there. Now, the review that we've written, which is on the web and actually going to be in the journals, we've given it a title, The Corporate Law Dilemma, Legal Professional Privilege versus the Need for Disclosure. It's the old story, if you like. Now, my wife Elizabeth and I have written this review on the basis that this book will be of great help, I think, to quite a wide range of professionals. And this is what we say. We've said transparency, openness, disclosure. These have become the watchwords of modern business, to the point where it has become an almost incontrovertible truth that large corporations especially must regard these criteria as part of an indisputable ethic to which their business must adhere. It's very much part of what has been happening at the end of the last century, therefore, in the part of the 21st century, of looking again at the ethics of how we conduct ourselves. However, enter the concept of what we call legal professional privilege, which you all know about, and this excellent book from OUP, which is devoted to the subject and examined in a clear, lucid and robust manner by Andrew Higgins, who explains legal professional privilege is the protection given to confidential communications between lawyers and their clients in connection with legal advice or litigation and preparatory materials thereto. Clear definition for you there of what it is, just in case there's any doubt. Therefore, legal professional privilege enables clients, specifically in this case corporate clients, to discuss all issues pertaining to a case freely and ostensibly without fear that confidential information will be disclosed. In other words, you've got to have a level playing field, if you like, but when you're discussing private matters, they've got to remain private, because otherwise how are you going to be able to advise your client sensibly? If you think about it, it's common sense. There's another quote which Higgins comes up with. All major common law jurisdictions, he says, recognize that powerful reasons exist for protecting lawyer-client communications and preparatory materials for litigation from compulsory disclosure. And there are 4 common law jurisdictions which he looks at in the book: England, Australia, Canada, and the United States of America. The obvious downside, of course, to all this is what Lord Justice Longmore refers to in the foreword as the tension between the wish of a person to avail himself of legal professional privilege and the needs of society for disclosure of relevant material if disputes are to fairly resolve. All too often, of course, the law emerges as unclear on this sometimes fuzzy demarcation between, for example, legal professional privilege and the public's right to know. And we've been here before, and it's especially important in areas pertaining to large companies and the public which they serve. Longmore goes on to say, but any lack of clarity will be much ameliorated by this book. In other words, the book is obviously giving you as much information as possible when you're advising the larger companies in this area. Disputes about privilege, Higgins points out, are frequently litigated in the courts, and it is usually corporations doing the litigating. Of course, he is very experienced in this particular area. Therefore, practitioners and academics will find most, if not all, their questions answered regarding legal professional privilege in this enlightening volume. There have been other ones before this which have been much more general, but this is a very specific area for those involved in it, certainly in terms of legal research. As I say, it's an enlightening volume by virtue of its clear multi-jurisdictional approach, which, unlike some treatises on the subject itself, does focus on corporations. As I've indicated, there are some books available which are much wider in looking at the whole issue of this type of privilege. Undoubtedly, therefore, we think it's destined to become a definitive work in what is a difficult and invariably controversial area of law. And the book, we think, will be welcomed by corporate lawyers working not just in the United Kingdom, of course our own jurisdiction in England and Wales, but also in the other 3 common law jurisdictions which are examined. It's quite interesting to note that the table of legislation, as well as the cases that I showed earlier, lists some very famous corporate names across the 4 jurisdictions concerned. Let me conclude by saying that corporate lawyers, and indeed anyone wishing to explore in depth the tension between the need for transparency and the reluctance to disclose, will particularly value this book, which is extensively footnoted, as I've indicated throughout. The law is stated as at the 1st of October 2013, and there is a November 2013 decision of the High Court of Australia, which has also been included. As I've indicated, you can see, just to repeat, what the book has got. That is actually the foreword that I referred to earlier by Longmore, which is worth reading. And then obviously you've got the normal cases I mentioned. 3 Rivers, for instance, is there. And you've got, again, the preface itself and a lot of other information. And the table of cases, as I said, is particularly important. I'd like to thank everyone concerned for producing this, because I think it's an excellent contribution to what we're doing, and I hope this review is of some help to people who are dealing with this particular area of law. These reviews are aimed specifically at people who, like myself, are practitioners, and we're looking at areas where we might need to just freshen up a bit of our knowledge and our tactics. So thank you all very much indeed. Bye-bye.